you. Perfect. I want to preface this with the fact that the legal sphere is very complicated and does have inherent biases that can come into play. Before I jump in, every human interaction is very different. So there's no one way to recommend a perfect solution for every litigation uh, situation that happens out there, as we all know as attorneys. A little bit more background about me. I have been in the disability policy sphere for about 10 years now, probably, and then decided to attend law school because I had found that there were some barriers if you didn't understand the law. And so I wanted that another tool in my toolkit, as you would say. So that is my journey to the legal sphere. But before that, I was heavily involved in international, national, and local disability policy and different solutions for better representation. I have a shortish PowerPoint that I can share just to get us started. And I want to have this as open as possible. So if you have any questions, Alexandra is going to be monitoring the chat and I can stop at any time and answer those questions. So feel free to ask them at any time. Let me pull up. Oh, yes, thank you. The written materials, they have a lot of good information. I like to provide a lot of information and different types of theories and methodologies that you can look into more, because my ultimate solution for all of this is that we can all be a bit more knowledgeable about disability and the disability community and create better outcomes in the law because of it. All right, Alexandra, can I ask you if that is showing up correctly?
Yep, that is.
Perfect, thank you so much. So we're going to be talking about disability specifically in the legal sphere today. There's a lot of different cross-sectional issues and interesting intersections that come into play. And I first, before we get started, want to lay a groundwork. This is a brief agenda. I want to lay kind of a groundwork for everything because it really will help us to be more knowledgeable about potential solutions that we can have in difficult situations that we've experienced. Some of the things I might talk about might be different than you've had in the past or different perspectives, and I encourage us all to be honest, but also, you know, have grace and open yourself to new ideas. So I'm going to go through a little bit of a background about disability in general, so we can all have a ground to stand upon. It's more complicated than I think a lot of us kind of brush over sometimes. And then specifically disability and the legal profession. We're all attorneys here. We may all be litigators, may not. But I want to talk about both clients and attorneys that are disabled and the actual intersection between those two is more than one might think. And then I also want to leave it open for questions at any time. I'm an open book. So please just interrupt me if you have any questions. I guess I forgot to introduce that I am a member of the disability community as well as an attorney. I have both invisible and visible disabilities. And And those, I mean, we all know that attorneys may have invisible or visible disabilities, but it's important to recognize that attorneys do have disabilities of all sorts. All right, so throughout this presentation, I want to address first what I mean by disability, and I'll be using it throughout the presentation, and so we got to address it. Disability, as I use it, is very, very, very broad. I cannot emphasize that enough. It's really a continuum of any physical, mental, learning, neurodivergent, psychological, temporary, or any other bodily difference that we have throughout, our global population. It's really broad. I think some people don't consider disabilities maybe like ADHD or chronic illnesses or clinical depression or PTSD. When I'm talking disability, I'm talking about all of those. I'm also talking about temporary disabilities, which could be even things like pregnancy, which is a medical condition while you are pregnant, or if you break your ankle or anything like that. So this definition is my own that I will use in this presentation, but it is based off for consistency an internationally accepted legal definition of disability, which is from the UN Convention on the Rights of Persons with Disabilities. And that definition includes anyone who has physical, mental, intellectual, or sensory impairments which, in interaction with various barriers, may hinder their full and effective participation in society on an equal basis with others. I like to state that because that definition itself has been ratified by around 168 countries. So it's a definition that's pretty prudent and widely accepted. And I will get into this later, but the law within the US and the disability definition is very difficult and is not narrowed down. So we're going to be using the United Nations one. So over the last 20 years or so, there's been a definite push for diversity, equity, and inclusion, DEI focuses as a core tenet for many businesses and organizations, including the legal field. As we all know, we now take, non-biased CLEs such as this one. And so there really has been a push, but we still have not seen disability as an identity that is talked about as much in those spaces. And I just want to bring that into the field and discuss that disability, as I talk about it, is an identity, such as any other identity that we would identify in the DEI space. And as with any other identities, there's different powers and privileges that come along with having an identity that is thought of a societally less than characteristic. Disability is obviously one of them because even the word can cause panic in some individuals. And this also goes to show there really is a very large intersection into marginalized identities and how people have multiple identities within this space. And disability is one of them, and they can compound. There's many studies out there that show that compounding identities that society deems they have the right to oppress lead to more compound barriers in the court system and thus lead us to having a more difficult time in going through those. So lastly, I want to give a few statistics. it's almost certain that you have had a client in the past that was disabled. 18 to 26% of people in the US do identify as disabled. And again, that is a broad spectrum of different disabilities, as we discussed. And then nationwide, though, only 1.2% of attorneys identify as disabled. And I think that's something we will get into about why that is. Large law firms have the most disparity. I believe 0.6%, so 0.6% of their attorneys identified as disabled in 2019, and then 1.2% in 2021. Another study has shown that there are only about 400 deaf or hard of hearing attorneys in the entire United States. And that's in comparison to the 1.3 million attorneys that we know of in the United States. We turn to the microcosm of California. 6% of attorneys are disabled. 24% of Californians identify as disabled, and 1.4% of California judges identify as disabled. So I want to take a quick break after all that and check in. I want to address why this is. Why are we so, why is disability as a word sometimes scare us? Why is it uncomfortable to talk about sometimes? There is what I like to call a continuum of disability stereotypes. Disabled individuals are extremely underrepresented in the law, and that often results in a stereotyping of them. So story time for me personally, so you feel more comfortable. I've had several invisible disabilities my entire life, anxiety and depression, but I also received a spinal cord injury when I was about 10 years ago. And so that means I use a wheelchair and I am paralyzed. So before that happened, I have been both using a wheelchair and then out of a wheelchair for a substantial portion of my life, about, half and half, give or take. And before I ever used a wheelchair, when I, saw somebody else, for instance, using a wheelchair out and about in public, I would feel terrible for them. And I would think to myself, oh, I am glad that's not me. And, nobody's ever saying that out loud, but, I definitely thought it. So I can, from being a more able-bodied person and having that experience, and a more disabled person and having that experience, I can definitely consider myself one of those people that have stereotypes about disability. So on one side of this continuum of stereotypes, I put subhuman. This is a stereotype of thinking any disabled person is lesser than a disabled person, and then an abled one. And you can see that trope from the story that I shared. You can see tropes of this in the media, the movies of, I'd be better off dead than in your life. A disabled person that, sits and mopes around in the corner. There's paternalistic identities here, and that when you see a disabled person, you think of charity or helping them out in some way, and you don't think of them as a full person. And that has a lot of basis in the historical legal field, which we will see soon. On the other side is the word superhuman. However, these are actually pretty much intimately connected, so don't see them as opposites of each other. This is the stereotype that you see of disabled people either, having superpowers because of their disability, or someone, for instance, if a disabled person does anything that is an everyday item, such as going to the grocery store, it's considered newsworthy. Whereas a non-disabled person, those types of activities would not ever be considered newsworthy. And I I want to clarify that, we see a lot of news articles around this and portrayals of disability. And the reason why this goes back to a stereotype that's connected to the subhuman stereotype is that if a disabled person does anything, if people did not think that disability wasn't a terrible, terrible thing to have, then depictions of disabled people doing everyday things would not be super uplifting or notable. It also usually objectifies or exploits the disabled person that is the subject of that stereotyping. So it all comes back to, it's gratifying to read about these kind of inspirational stories for non-disabled people because it's a more of it kind of goes back to, hey, I'm glad it's not me, and I'm happy that they can do a normal thing, and it's a lot harder for them to do a normal thing if that I think. So it's rather infantilizing them. So neither of these are fair or true portrayals of any one individual. In fact, all disabled people are not on this continuum of R, and I want to make that clear. Disabled people are people, and they have complex identities and human characteristics that are widely varied as anybody else. So we can't talk about present without going back to the historical barriers in the legal sphere. Historically, the legal system is one of the most stigmatized spheres for people with disabilities. I would probably say second only to the medical profession. Our profession is pretty bad statistically. So if you feel like there is a stigma out there, you are right. It's difficult to change, 100 years old legal system, but people are doing it. We are advocating. So one of the things that is difficult is our current U.S. legal system has a wide history of not treating disabled people as people, again, dehumanizing them. Just a few examples. In the 1900s, there was eugenics. There was a Supreme Court case, Buck v. Bill, which held that individuals with disabilities could be forcibly sterilized. And we see that in our effects in the law today. The Supreme Court just cited it in their recent Dobbs versus Jackson case. And the Iowa Supreme Court in 2014 actually held that a disabled individual could still be forcibly sterilized as long as there was court approval. So as the law goes and as litigation goes, disabled people have been seen as less than. Another few laws really introduce forced institutionalization in the United States to try and conceal and isolate people with disabilities. That is still bled into the court system today. And it was really any kind of disability, and it runs the gamut. I think people always think about, psychological disabilities as being those were the only people that were institutionalized, but it was a wide variety, and it continues to rear its head. And the last example I'll give is what's colloquially called as the ugly laws here in the United States. They were introduced in the late 1800s and 1900s, and primarily enforced then, which was municipalities basically banning any person with a disability that had, overlapping categories of any visible difference in their body, and they wanted to hide those. These laws, again, were still in practice until 1974, which they were used to arrest one man with visible scars on his body just because of those visible scars. So this is not it's not a foregone conclusion or a long time ago that these laws were in place. It is quite recent. Let me plug in my computer because it has come unplugged.
Well, Kendra is addressing the computer. If anyone has, I just want to emphasize Kendra's point earlier. If anyone has any questions throughout the presentation, please feel free to either drop them in the chat or ask them. Where this is ultimately a conversation that we want to start having.
Thank you all for your patience while I work through technical issues. As Alexandra said, is there any questions about the historical basis for kind of this stigma in the legal sphere? All right, and then lastly, I want to address, which I think we all know to a certain extent, but the legal sphere and the legal profession in and of itself, the court system especially, it's rather slow to innovate, right? It's rather slow to take on new technologies, new research, new scientific research, anything regarding, newness. It really is a very old profession, and has its, stare decisis and other things that might, keep it from innovating in some sense. So, the slow to innovate does affect how marginalized people of very various identities are perceived within the legal sphere, and whether or not they even have access to the legal system and to litigation. So I want to talk about how those historical things I mentioned have an impact on the law today. So, for instance, there is a very large socioeconomic impact, especially for attorneys with disabilities. There's been studies that have shown that, individuals do not tell anybody about, chronic illness or a disability of any sort because they fear losing their employment. This goes straight back to that statistic that I raised about 1.5% of individuals identifying as an attorney with a disability, especially in, big law firms, because hey, there's such a stigma and you are supposed to be as competent as possible. Um, if there is any inkling that you have what is still considered to be stigmatized a disability, you cannot share that. And so there have been studies where even though there's that only that 1.5% in big law firms, of course, uh, throughout public interest and private interest, there's more surrounding about 6% in California. But the analysis of that is that there is so much pressure placed upon attorneys to appear as competent, as we see in the model rules, and compelled to appear incredibly physically well, because it would be considered an outward showing of, incompetence. There's also shown of uh, people really, getting fired or again with the professional rules of conduct. And we can talk about this later, but there is a rule that says if you're disabled, then you shouldn't be practicing law. And there have been cases where an attorney has received sanctions for this in regards to competence. And so there's just a lot at stake here in the legal field. Accessibility as a word directly conflicts with those professional stereotypes that we have about the legal field. This is hugely apt throughout the legal field, as a recent study showed that attorneys have a overwhelming amount of mental illness and suicide risk because of the high stress that they incur, especially in, impact litigation. So it's very common for an attorney to actually have, some sort of medical condition. But the stigma means that they're less likely to seek any care for that mental health or other health issue. And this can snowball and cause burnout. And then burnout will lead to, emotional exhaustion, impaired job performance, and notably, less competence, as we see, and less ability to do your job. So, in order to ensure that the legal representation for disabled individuals is fair and equitable, we also really need to have disabled attorneys as well, and disabled attorneys that feel confident in identifying as disabled, that they don't have to hide that part of their identity in order to be employed or be competent, and to not feel scared to, get the medical help that they need so they can continue to have a working body in order to provide the best care for their clients. All right, so
there is a question in the chat, Kendra, from Donald.
Hi, Donald.
Would you like me to read it, or do you have it up?
Donald says, are we making progress statistically from past historical bias in the legal profession towards the disabled compared with among the general population? Donald, I'm going to answer that, but let me know if you mean something else. I think, of course, we're making progress. We can see day to day that for a long time there were no disabled attorneys, and also very few disabled clients were able to even access the court system. So I 100% see that there are progress here. It is slow progress, but it is definitely progress. And that's why we need to continue having these conversations, because I think at the end of the day, we will make a lot more progress if we feel more comfortable around the subject, about talking about it, and that it's not a taboo. So I think we can make even more progress with that. All right, so as I was saying, there really is a cycle of stigma that leads to poor outcomes. And when I say poor outcomes, that means poor outcomes for attorneys in litigation, and it means poor outcomes consequently for their clients. Any sort of stigma where it affects the ability to, for you to get medical care, for you to be able to receive the accommodations that you need to even feel confident expressing those accommodations or asks, it's going to affect your workload, and it's going to lead to poor outcomes for our clients, which is the exact opposite of what we want to do, which is to zealously advocate for our clients. And then I really want to emphasize the fact that holistic perspectives, which means that more diverse perspectives of attorneys with different identities within the law, makes better law. And so if you don't have any disabled people that are attorneys, how are the 20% of the population, 24% of the population for California, able to get the justice, the respect, and the understanding of the issue that they deserve as a client without, ever having that experience yourself? And so I think it really does make a huge difference on providing better representation within the legal field for our judges, for our attorneys, which will then filter down to our clients. All right, so I want, we have some questions, we have some hypotheticals. I want to talk about how different disabled individuals will always have better ways to organize the legal system, better ways to clarify things. There'll be better counter arguments and arguments when you have the innovation that comes from disabled individuals that have different perspectives than an able-bodied person. And it will create a better and more effective environment. I'm also, as you've seen, there are some systemic changes that need to be made in the legal system in order to provide a better system as a whole. And I think people are working on it, and I think it's happening. And I think we were just making sure that in litigation, in the court sphere, that disability is at least talked about. That's just a start. It's not hidden, it's not seen as like taboo to even talk about. You don't want to say anything about it if you have anything going on there. Also, there's many strategic things that you can do to emphasize or de-emphasize disability. But it really is the overall solution is to make sure that people with disabilities have the justice that they deserve. And I want to stop this PowerPoint unless people want it up. And open the floor to anybody who has any questions. This was a very brief overview, and there is a lot to talk about here. So I wanted to open it up and know that this is a learning experience. There's a lot to learn, and I continue to learn every day.
So I'd actually like to jump into the question of my own that so we've talked about different methods of the progress we've made, the type of progress we've made. I was hoping you can speak a little bit more as to what type specific examples of the legal standards or professional responsibility rules that would be applicable to accommodating and working with with people with disability or people providing care to someone with a disability. So I was hoping you can talk a little bit more about that.
Yeah, of course. So, from a rule perspective, which I saw you cite about, in the civil litigation context, the model rules, both the model rules and the California Rule 1.16, which is declining or terminating representation. This has brought a very large discussion and very robust discussion among the disability community and disabled lawyers in the past few years that I've seen. In the civil litigation context, the rule that is 1.16 has been cited primarily in cases involving sanctions or legal malpractice or withdrawal. Recently, or as I think of 2020, the rule was slightly changed in wording, which does make it and that's in California, not in the model rule. So go California. The rule is slightly changed, so it is a little bit less harsh, but the rule is usually cited when anybody is like, for any reason, thinks that there is a physical or mental condition, which is what the rule says, that will inhibit a lawyer in any way. And that has led a lot of lawyers to say, well, if the law says that, how do people know that if I say I have a disability, it's not limiting my representation anyway? In fact, it's a lot of times it's really helping me emphasize with my client, understand innovative ways to go about litigation, see things in a different way that maybe somebody else wouldn't have, and catch innovative legal arguments even. But people would be scared even to report that because, you know, the law, that rule's kind of vague. And it has been seen in the past. But one of the improvements I have seen is the California slightly modifying it. For I mean, for everyday disability law, the court is under the ADA Title II, governmental entities, and they must provide equal access to people with disabilities. And that means people who are attorneys with disabilities, that means employees of the court system, it means clients, it means anybody that's getting in and out of there. So we've seen that the court has been slow on the uptake to acknowledge the ADA sometimes. And I think that was on one of my slides that I forgot to mention, but the enforcement of different ADA laws is fairly difficult to uphold in a court setting. Even though you'd think that the court upholds the law, just because of the stigmas and the historical basis of what I talked about, it is one of the more difficult places, I would say, to, you know, get accommodations or advocate for your client, for instance. But there is also, and I provided these resources on the resource, so y'all will all have access to it. The court has a policy. It has MC 410, and you can fill out that form and request accommodations. It's a statewide form, just like any other. There's also California Rule of Court 1.100. That rule talks more in depth about how the court system is expected to implement accommodations or even work with anybody with a disability. And I've also collected a kind of a living document table of all of the California Superior Court reasonable accommodation coordinators, which is who you would go to if you did need a reasonable accommodation in court. They're kind of hard to find sometimes, so I decided to collect them all in one and keep that as a living document.
I guess what I like to do now is get into a couple of hypotheticals, some practical experiences. And again, anyone has any questions or any experiences they would like to share and discuss, please feel free to reach out in the chat. So situation that I've encountered over the past where an attorney has a disability and the attorney wants to defend the deposition. But due to their disability, they need to limit the deposition to 4-hour block sessions over 4 days, which, as we all know, a deposition can go for 8 hours, more or less nonstop. Opposing counsel, it makes the argument that it places them at a disadvantage because they want the deponent to sit for the full 8 hours. I'd like to hear your thoughts on how you would handle this situation.
Thank you, Alexandra. That's a great situation to bring up. And I think it's probably pretty common. I just had this come up the other day. So I was in a deposition a few days ago. So obviously we all are at the dictation that you must zealously advocate for your client. I am never telling you never to do that. And I hope that you can tell from the stigmas conversation that we saw that there's no need to, patronize or infantilize any person who is disabled or who is requesting a reasonable accommodation. So the ADA itself on reasonable accommodations has provided actually pretty stringent countermeasures to ensure that the ADA is not being abused. Some of these include undue fundamental alteration, undue burden, financial constraints. These are all legal affirmative defenses that one can use if it is applicable to the case. My observation of this is that there really is no need to treat it as anything other than any other aspect of human life. So just recently, I'm in some pretty intense litigation right now, and we've had several depositions canceled on me a few hours beforehand, which was disappointing, and that had nothing to do with disability. That was just another life event that came up for the opposing side. And I've also seen recently an individual who was like, I have to end right at 12 because I have to pick up my child from school, and so we have to work with these human things all the time. Attorneys are not robots. And both of those instances, we're not disability related, right? But I think as professionals in the legal community, we can really, you know, try to intuitively know how to treat people like people. And if it is a very difficult burden placed upon the one party for giving a reason that has been asked to provide this reasonable accommodation, that's something you should discuss. You should discuss it with the person asking. You should discuss about the reasonable accommodation. And there is under law what's called the interactive process. I highly recommend it. It's where you sit down and you have a back and forth discussion with a disabled individual who's requesting a reasonable accommodation, and you make sure that you understand it, you understand what's going on and why this reasonable accommodation needs to be. And then also you can also discuss, are there any other ways to really get the same thing done, but in a different way, in a different accommodation that's not as burdensome to you. So I think for this instance, I definitely, you know, reach out and make sure to have a conversation with them. I know conversations can be hard, but this is one of the areas that we really do need to have those conversations. And as law firms, as to Title III of the ADA, law firms and the attorneys within it are under the ADA to provide reasonable accommodations. So there is that legal piece there that does say that we can't just, you know, ignore reasonable accommodations. We need to talk about them.
I guess that actually leads into that particular scenario does lead into a kind of a topic that, again, I hope that we've kind of talked about, and I hope we can speak a little bit more about, which is what can the legal profession do to better support lawyers with disabilities? What are the legal and ethical obligations of legal entities, the court system, law firms? Arbitration is another one that comes to mind. What is the role of these organizations in terms of what's obligated versus what's really is just simple human?
Yeah, that is a great question. I'll just start off with big overview. Title I of the ADA covers employment discrimination. That would be if you are an attorney with a disability and you are discriminated against in your law firm. That is the law you go to. Your law firm does have an obligation of, one, reviewing your reasonable accommodation. Then if they disagree with a reasonable accommodation and can raise one of those affirmative defenses, then you need to go into the interactive process, which is, you know, sometimes closer to a mediation, and trying to find different ways that you can either provide the accommodation, which can be, you know, this is all innovative, which is why I always say I think when we talk about reasonable accommodations, we're like, oh, well, maybe it's just extra time usually, or, you know, different accessible technology is common. There's kind of those boilerplate accommodations, but a lot of times I definitely strive for really talking about how accommodations can be really personalized, and then for the good of both parties, it'll make sure that it's an effective measure of time and an effective way to engage with less of a burden on both parties. So Title II protects discrimination in governmental entities. That's the court. That's Title II. Title III prohibits disability discrimination in private entities like law firms. And I think this is where you would get into the back and forth and the obligation that you as an attorney in a law firm litigating have to provide non-discrimination to opposing parties, even if you don't like them. You still need to follow non-discrimination laws under both California law and the federal law. California law has some very specific disability laws, but they basically either, you know, repeat what the ADA says or slightly enhance it and give better and more efficient wording to it. So I guess I want to address that in terms of obligations, we are obligated to follow anti-discrimination law. As lawyers, as attorneys, as judges, we're not exempt from that law, and that includes the ADA, which was originally modeled directly off the Civil Rights Act. So they're actually very similar, and we're obligated under all of those laws. So this means that we do need to strive towards providing reasonable accommodations, and the ADA does say that you need to provide the reasonable accommodation unless there's affirmative defense. And the accommodation that somebody seeks is usually the best accommodation, because they understand their body a lot more than you do. However, you can still talk about it and you can figure out, you know, like with my specific circumstances, your accommodation is not going to work for our firm or whatever. Under, you know, the ADA, obviously, not just you don't want to do it. But if you can, you know, talk about it, go through that interactive process, there's always ways to really go through things. And it's not like you just have to blindly accept or deny a reasonable accommodation, but it is obligated. The bottom line standards are anti-discrimination laws.
I'd like to switch gears a little bit here. So here's another situation. This is actually a situation that I've encountered in my own practice, where you have a plaintiff in a case, and that plaintiff has a prolonged history of delaying discovery. And as you're approaching the discovery cutoff, the plaintiff starts to claim a need for accommodation due to disability. What would you do in that situation where you have a plaintiff with that history, but you also don't want to just assume that this is another delay tactic, but you do also need to advocate for your client? So I'd be curious to hear your opinion on this scenario.
Yes, and I'm not sure. So the clients themselves are asking for the reasonable accommodation now. Is that correct?
The plaintiff.
The plaintiff, and you're the defendant.
Yep.
Perfect. All right, just wanted to clarify that. So at the other, when you're talking to opposing counsel on the other side, it's difficult to understand, you know, what they're actually thinking, right? I think we run into that often. It's like, are you just doing this to be very frustrating to me, or is there something else going on? When a plaintiff asks for reasonable accommodation, I first want to preface that a lot of times, again, with stigma, which is you know, maybe not, there's still stigma outside of the legal field. And so if a plaintiff is expressing that they have a disability, I think that makes it pretty known that they might actually have a disability, because it is very difficult to express that in our work. I know it's difficult, maybe if I would say it's more difficult to tell if maybe the attorney was like, hey, like threw it up all of a sudden, which I'm kind of maybe thinking was the case. But at the end of the day, we have to be more cautious of the way that we're perceiving others, and to not make assumptions. So, I mean, throughout all of that, I think you can still say, hey, if there was these different instances, and make sure to document the different instances of delay tactics on behalf of whoever your opposing party is, that weren't even disability or were anything, and understand that for purposes of both anti-discrimination disability law, we have to, believe that people do have disabilities. And that's what probably trips up a lot of people, is like they're like, there's a lot of stigma around disability as excuses, or they're just using it to get extra things. And that's what people think of as a reasonable accommodations a lot of times. They're like, oh, they're just getting like extra things that I'm not getting. But if it is truly somebody asking for a disability accommodation, they've expressed that they have a disability, they've expressed that there's a nexus between the disability and the accommodation specifically, then our obligation under law, both as human beings, is to make sure that we're providing the accommodation in a manner that's feasible for both parties. So the end all be all is, especially in a litigation realm, of course you can bring up, if you need to bring up to the judge, this person has been delayed on these five separate different occasions. But I don't think the judge would be very happy if you did bring up that you think they are not really disabled because they also used a another tactic, and you think it's a tactic to provide more time. So it's definitely a catch-22 a lot of times, I think, for attorneys, but these delays happen all the time, and it has nothing to do with the disability. So we that is definitely the end all be all of litigation, is hurry up and then wait. But according to legal standards, we do need to provide reasonable accommodations.
We do have a question from Natasha in the chat.
Perfect. So this question says, what is the best practice and legal way for asking a potential or new client if they need accommodations? I had a Zoom consultation with a potential client who was visually impaired. I didn't learn about this until some time had passed. All right, this is a great question. Really great. So one, I just want to address there's stigma in there. The visually impaired client was probably really scared to tell you that they have a visual impairment before being a potential new client, because they think, you know what, they're not going to take me on if I'm visually impaired. They don't want to deal with that. That's the stigma that's based in society. So I can definitely see there is a reason why they didn't tell you. That's one of the reasons that I really emphasize on, sharing your ability and not feeling that it is a bad thing just to say you have a disability. I'm very confident in my skills as an attorney, and I can also say that I have a disability. Those two things do not mean that I am less effective of an attorney. So, but there's obviously the client may have had some stigma, and it was like, I really need an attorney and I don't want to like freak them out with any extra things. I probably already have a problem that is kind of complicated that I want this attorney to fix. That might be the client's thinking. And then what is the best practice and legal way? So there are lots of templates online, but I always, when addressing new clients, you can always go down when you confirm, say, you confirm the time and with the client for this meeting, and you say, hi, if you can be proactive. You don't have to wait for them to address it. Just be proactive and say, hi, thank you for meeting with me. This is the time that we're going to meet. And then put a little paragraph, which lots of templates out there that says, hey, if you need an accommodation, or you can even say something as simple as, if there's a best format for us to have this meeting in, that would be, the best for you, let me know and we can do it in that format. You don't even have to say the word accommodation if you don't want to. But there are lots of little phrases that you can say to just, state that you're comfortable with them expressing their disability. Just you raising it is huge, because they live in a society where disability is taboo, not talked about. And so just you raising it and having the empathy and the consideration to be like, hey, if there's a form that works best for you, just let me know. And so I think it's kind of like boilerplate to this, like, that's the best way to do it. It's like not even worry about it, just ask everybody. If they don't need it, then they don't need it, no harm done. But just use it as boilerplate in your discussions with new clients or potential clients.
So if we don't have any, I actually have one more here. We've talked about the courts, we've talked about law firms. So would like to hear your thoughts on what bar associations and professional legal organizations can do in promoting the inclusivity and accessibility with disability within the legal field for lawyers with disabilities.
That's a great question, Alexandra. So I think one of the things first off of is doing what Contra Costa is doing, having the conversation, starting the conversation. This lovely meeting is great, and I want to applaud Alexandra for reaching out in the first place, because that's starting the conversation. Second, another thing that Contra Costa is doing is actually starting a disability group within the Bar Association as part of DEI. A lot of times, as I mentioned, DEI considers different identities, but it doesn't consider disability as one of those identities. And what's partially so important is, yes, somebody with a disability definitely needs to be included in those discussions to have robust discussions, but also individuals who have other marginalized identities, for instance, race. There has been multiple studies that have shown that Black or brown individuals with disabilities are much, much more often to be discriminated against because of the compounding factors of both disability and race in these oppressive systems. So if you just have one identity, I mean, people really are an amalgamation of all their different identities. And if you just address one part of a person, you're not really addressing the whole holistic problem, and then you're leaving something out. And at the end of the day, that's not the holistic goal, and that's not true inclusivity. So I've seen a lot, as we've discussed, bar associations really, first of all, starting up DEI organizations, which is great. DEI can sometimes seem as, sometimes lip service, and we have seen that. So to make sure that the DEI group that the Bar Association has is conducting, actual change within the legal system. They're doing presentations and they're doing real research. They're trying to figure out and identify different areas where the people in their sphere of influence, which is their little legal community, have access and feel like they're included in the legal community. Because a lot of times we don't see individuals of different marginalized identities as a lawyer. We don't have that image in our head. We're not like, oh, that person in a wheelchair is definitely a lawyer. Oh, that person, who has a visual impairment. Oh, yeah, you can definitely be a lawyer then. You just don't see it. And so it's so important for bar associations to really recognize that and uplift it. Uplift those voices, because then, the new little law students that come in to law school and maybe they just found out they had some sort of disability, and they're panicking because they don't think, they'll never get a job. They've never seen somebody with a disability in the legal sphere. They don't have those thoughts. They've never heard of anybody discuss it. And, they're panicking a little bit. I know, when I was a law student, I felt like that at times. And one thing that my bar association did really well is we also have a disability group as part of our DEI, and they did mentorship. So I was paired up with somebody who had an invisible disability, that was an amazing, fantastic attorney that's been an attorney for so long. They're now a judge. And I got to, just seeing him not do anything but, be an attorney was enough for me to be like, wow, I can also do this. So mentorship is also really important. And I think that will improve our up and coming attorneys that we want to grow into, excellent litigators.
Wow, thank you so much, Kendra, for that presentation and this discussion. We really appreciate you taking the time out of your day to do this. On that note, thank you everyone for attending this program. You'll get your materials and your certificate via email, so keep an eye out for that. Thank you, Alexandra, for putting this together. I hope everyone has a great weekend.
Thank you so much.
Bye-bye, guys. And thank you guys for the positive feedback in the comments. Thank you guys.